May I have appearances at least for the felony cases?
Good morning, Your Honor. Jeremy Bear, Assistant Prosecutor for the People.
And Your Honor, I have confirmed, and other people in my office have confirmed with Mr. McConnell as well, that he does not want an attorney for these files. He's representing himself.
Okay, thank you. Mr. McConnell, could you please state your name for the record?
Yes, Your Honor. Israel Jones McConnell.
Okay, thank you. So at this time, this is the time and date set for a probable cause conference. So first, I'll go to Attorney Bear. What do you have for the court this morning?
Your Honor, well, no, we were waiting for an appearance from an attorney. I only learned this morning that Mr. McConnell wishes to represent himself. There is no plea offer at the district court level. We would urge Mr. McConnell to waive his exam and seek a resolution for his various cases in circuit court.
Okay, thank you. So, Mr. McConnell, at this point, sometimes prosecutors offer plea agreements, plea bargains. A plea bargain is what it sounds like. It's a bargain. If you give up your constitutional right to a trial, you get something in exchange.
Wow.
Now, here's the thing. You never have to accept a plea bargain, but the prosecutor also doesn't have to offer it. Think of it almost like a gift. No one has to give you a gift, and you never have to accept a gift. So what Attorney Bear is saying at this time is there is no plea bargain on the table. So the next question before the court is whether you wish to proceed with a preliminary exam. So if you were to proceed with a preliminary exam, we'd come back, we'd be in person next Thursday, and there'd be a court hearing where the prosecutor would have to convince the court to have a reasonable belief that a crime was committed in each case, and a reasonable belief that you had something to do with the crime. It's not beyond a reasonable doubt. It's a much lower standard, but they would have to provide some evidence. So what questions do you have about a preliminary exam? Just the preliminary exam questions right now.
Well, there's a few things that we need to talk about, but I guess that's one of them. And then there's 3 charges. The third charge, could you read out the charges for me?
Sure. In case 260162FY, you are accused of, in count 1, second degree fleeing a police officer, and the specific allegation is that on or about August 22, 2025, at Grand River Road and Abbott, you were the operator of a motor vehicle who was given a visual or audible signal by a police officer who was in uniform and in a fully recognizable patrol car, and that you did not stop the car. In count 2 of that case, you were accused of operating while intoxicated or impaired. So the allegation is that you did operate a motor vehicle upon a highway, Grand River Avenue, while under the influence of a combination of alcoholic liquor and a controlled substance. That's punishable by up to 93 days in jail and or up to $500. However, there's a second offense saying that you had a prior OWI in 56A District Court. So that increases the penalty to up to $1,000 in fines and between 5 days to 1 year in jail, along with some other penalties. In count 3 of case 260162FY, you are accused of driving on a license that was suspended, revoked, or denied. And again, on August 22, 2025, you are accused of driving on Grand River Avenue in the city of East Lansing while your driver's license was suspended or revoked. In count 4, you are accused of reckless driving, again, same day, also Grand River, driving in willful or wanton disregard for the safety of persons or property. And lastly, in this case, you are accused of unlawful use of a license plate. And the allegation is that you did carry or display upon a Camaro a license plate that was not issued for that vehicle. In case 260167FY, you are accused of interfering with a crime report, threatening to kill, injure, or cause property damage. And the specific allegation is that on or about February 23rd, 2026, you did, through the unlawful use of physical force, prevent or attempt to prevent another person from reporting a crime committed or attempted to be committed by another person. And the violation involved committing or attempting to commit, interfere with electronic communications. This is a felony punishable by up to 10 years in prison and or $20,000 in fines. A consecutive sentence may be imposed for any other crime, including any other violation of law arising out of the same transaction. In count 2, you were accused of interfering with electronic communications, and the specific allegation is that on or about February 23rd, 2026, at 524 Curtis Road in the city of East Lansing, you did willfully and maliciously prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an authorized communication by or through a telephone or telephone line. And this is a felony punishable by up to 2 years in prison and or $1,000 in fines. In count 3, you are accused of making an assault or an assault and battery upon Fern Preston. This is a misdemeanor punishable by up to 93 days in jail and or up to $500 in fines. And also the court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition if it was not taken at arrest. In case 26, got a lot of files here, Mr. Dillon. Let's see.
I'm sorry I put you through that, Your Honor.
No, that's okay. No, you have a right to know, and I'd prefer that you know that rather than not.
The reason
Okay, so wait. One more file here. In case 260170FY, you are accused of attempting to disarm the firearm from a police officer. And the specific allegation is that on or about February 23rd, 2026, at 1215 East Michigan Avenue in the city of East Lansing, Ingham County, Michigan, you did attempt the following listed offense, and in the attempt did act towards the commission of that offense, but failed in the perpetration or was prevented in the execution. So that would be disarming the firearm from a police officer. And the allegation is that you did take a firearm from the lawful possession of Wyatt Keith, a peace officer with the East Lansing Police Department. This is a felony, punishable by up to 5 years in prison and or $5,000 in fines. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. In count 2, you are accused of assaulting, resisting, or obstructing a police officer, causing injury. And the allegation is that on or about February 23, 2026, at 1215 East Michigan Avenue in the city of East Lansing, you did assault, batter, wound, resist, obstruct, oppose, or endanger Wyatt Keith, a police officer of the East Lansing Police Department that you knew or had reason to know was performing his duties and caused a bodily injury requiring medical attention or medical care to that person. This is, again, a felony punishable by up to 4 years in prison and or $5,000 in fines. In count 3, you are accused of assaulting, resisting, obstructing, causing injury, again, to a police officer. And the specific allegation is that you did assault, batter, wound, resist, obstruct, oppose, or endanger Jason Pass, a police officer of the East Lansing Police Department that you knew or had reason to know was performing his or her duties and caused a bodily injury requiring medical attention or medical care to that person. This is a felony punishable by up to 4 years in prison and or $5,000 in fines. A consecutive sentence may be imposed if the assault was committed in a place of confinement or for another violation arising out of the same transaction.
Your Honor.
So that's what you're charged with. Now, I cannot give you legal advice, but I can give you life advice. And my life advice is this. A lot of people think lawyers just go to law school to learn how to talk. That's not true. My long-suffering mother had 3 daughters, and 2 of them became lawyers to her eternal shame. She can tell you that we knew how to talk. What lawyers really know how to do, what lawyers know how to do is how to move the pieces around the Monopoly board. You've probably played Monopoly. There are different rules for playing Monopoly, depending on which version you're playing. Monopoly is a game like basketball is a game, but there are completely different rules. What the attorneys do for you are decode the rules and help you get through the process. So I can't give you legal advice, but I can give you life advice. And my life advice is this. If someone I cared about were in your position, I would beg them to get an attorney to help them through this
Your
process.
Honor, that I have something very pressing to bring to your attention right now. And
Okay.
when I asked that question, I wouldn't have put you through that whole entire, line of answering, but the guards brought in a whole prisoner and they also cleaned out a whole cell and they did all this stuff. So I heard everything you said, but there was no hope for intervening.
Okay, that's okay. Actually, that's fine. And that's also what I'm here to do. So that's fine.
So do you remember about a week ago when we talked the first time and do you remember saying that on the two charges that were $100,000, I believe it's the basically having the scuffle with the officers.
And that's actually case 26-0170-FY. And
do you remember saying 10% surety, cash surety?
No, what I said was cash surety, which is different than 10%. So it's $100,000 cash surety, not 10% cash surety, meaning you would likely have to work with a bail bondsman or find some way to post the equivalent of $10,000 with the court before you could be released. So that would either be $10,000, well, hopefully not in cash, and like a cashier's check with the court, or the equivalent in some sort of collateral, but it's not 10%.
But you do remember saying it would be about $10,000 on each charge, and it sounds like
No, $100,000. $100,000 in case 26-0170-FY and $100,000 26-0167-FY and $100,000 in 26-0162-FY. So each of those cases would require $100,000 in cash or collateral, but not 10%.
Your Honor, would you be willing to consider me for 10%?
So what I'm hearing is a request for a bond modification, a motion for bond modification. And so I will hear your request. Why would you like the court to do that?
I have puppies that are in the pound right now, and they're all I got in this world. And I want to work with the court and get this whole case taken care of. You did make the tether a condition of my release. So there's no getting away from any of this, and I have no intent on getting away from any of this. But I do want to make bond so I can continue my legal matters in other counties, so that I can get out on bond and work with the courts further from there. And if I could have 10% surety added to my bond conditions, $10,000 for the charges, per charge, then I could make bond, and I think my chances would be quite more significant.
Okay. Now I'm going to let the people respond to your motion. So, Attorney Baer, a response to Mr. McConnell's motion.
Your Honor, we would oppose the motion on two grounds. Based on the allegations, the defendant is both a flight risk. He is accused, among other things, of trying to escape police custody while sitting on a hospital table. And the allegations are also, at least some of the allegations are also violent in nature, and we believe he is a threat to public safety. Therefore, we would deny this motion, oppose this motion. Thank you.
Okay, so Mr. McConnell, you've had your say, then the prosecutor gets to speak. Now I make a decision. And at this time, I am going to keep the $100,000 cash surety bond in place because I am gravely concerned about public safety. The charges are unproven and you carry a presumption of innocence. However, the court also has to consider the likelihood of your appearing for court, which I am going to estimate as probably quite low. I have to consider the likelihood that you'll follow other court orders, which I would say are 50-50, based on just what I know so far. Okay, there's a lot I don't know about this case. I would have to consider danger to the public. And in this case, we have separate allegations of violence against different people on different dates. And that is gravely concerning.
Your Honor.
So at this time, I am not going to reduce your bond. It remains $100,000 cash surety with the other conditions if you post them. Now, what we're going to do is come back next week, okay? We're going to come back next week. We will bring you here in person on Thursday morning. So what you have to decide between now and then is whether you want to have a preliminary exam. So a preliminary exam is a court hearing where the prosecutor has to bring enough evidence to give the court a reasonable belief that a crime was committed and a reasonable belief that, just a moment, that you had something to do with it. It's not beyond a reasonable doubt. It's a much lower standard, but they have to bring some proof. So
I'm aware, Your Honor, but I'm asking you for an opportunity to respond.
Okay, well, the way things, and as I told you, what attorneys know best are the rules of the Monopoly game. So you had an opportunity to speak. Mr. Baer had an opportunity to speak.
But I was not.
So that's the rules of the game. That treats everyone fairly. If
Representing myself, I believe.
Mr. Baer could not, I don't want to mute you, but I'll do it if I have to, but I really don't want to do that. If Mr. Baer had said something, you would get an opportunity to respond, and then he would not get another opportunity. So these are the rules that treat everyone the same. So what you need to decide next, Mr. McConnell, are whether you want to have what we call a preliminary exam and whether you want an attorney. Again, I can't give you legal advice, but if you were my beloved nephew or some family member, I would beg you to get an attorney because of the severity and number of cases you're facing. That is your choice, and only you get to decide that. Yes, sir. Yes, sir.
You will let me respond? Okay.
No, only if you have something new.
I do.
Something new.
I have something to add.
Well, no, we're not going to talk about bond anymore. Do you have anything else? Different issues.
You said that the reason that all, that it ends there and we have to wait till next week is because you think that I'm a danger to anyone and that I'm a flight risk, that it's not likely that.
Right. So we've discussed this now. This is another bond condition. So what you need to decide next, Mr. McConnell, I do not want to have to mute you, but I will if I have to. So what you need to decide next is whether you want to have what we call a preliminary exam. And more importantly, or more urgently, whether you want to be represented by an attorney. So may the record reflect that Mr. McConnell has moved away from the slot where he was communicating through the jail, and I can now see him through the window. So Mr. Baer, I think we're going to have to leave this on for preliminary exam, and we will.
Okay.
Actually, this will be back in front of Judge.
Is that better?
This will be, okay, so Mr. McConnell, we're going to leave this on for what we call the preliminary exam. Thursday, 9 a.m., you'll be brought here in person. I would highly encourage you to speak with an attorney about what's there and what your options are. So thank you. That is all for this record. Thank you.